In looking to see whether you can get your case into court, once you've resolved the issues of jurisdiction and venue, the last issue you have to address is standing. And standing really is three different things that you have to look at that all come under the general category of standing. But the three things under the general category of standing are standing, mootness, and ripeness. So let's look at each one of those. Standing means you have to be the one that was actually injured and therefore have standing to sue. The way they teach us in law school, they say is, if someone throws a spear at a group of people and the spear hits and injures one person there, the one that has the standing to sue is the one who was actually hit by the spear and actually injured. He has an injury and he has a legal standing to sue. The guy that was standing next to him that never got touched may be angry and upset about it, but he doesn't have standing to sue because he was not injured. So standing is, are you the actual injured party? And you would think that this is a silly concept, but it gets sticky and interesting when the government passes a new law that's going to raise your taxes and you want to sue the government as an angry taxpayer, but you haven't actually paid that tax yet. You may not have standing to sue. So that's standing in general, but within the general category of standing also comes mootness and ripeness. Mootness is sometimes by the time the case is brought to court, the controversy is already resolved and is moot. Maybe you hit somebody with your car, you went to see him in the hospital and you said, I'm so sorry, I know it's my fault, I don't want my insurance premiums to go up. I'll pay all your medical bills and I'll give you $10,000 for your pain and suffering if you'll promise not to sue me. And the guy says, okay, I don't want to go to court anyway. And so you enter into a settlement agreement and you settle the case. And then the guy decides, the injured guy decides, I didn't get enough money, my injuries are worse than I thought, and he decides to sue you anyway. But you get to court and you say to the judge, this case is already settled. It's now moot. The judge says, you're right, the case dismissed, get out of my court. So that's the mootness issue. The other one is ripeness. Sometimes a case is not yet ripe. Maybe your injury is not legally occurred yet. So you have a contract with a guy and he's supposed to deliver 10,000 bicycle frames to your factory no later than May the 30th. He calls you up on May the 1st and says, I'm still going to try to get those bicycle frames to you by May the 30th, but I want you to know we're having a strike at the factory and I might not make it. So you get mad at him and you sue him for breach of contract, and you get into court and it's April the 15th. And the judge says, wait a minute, you're suing this guy for breach of contract, it's May the 15th, he still has until May the 30th to perform. And he didn't say, I quit. He said he's still trying to perform by May the 30th. This case is not ripe yet. This case won't be ripe until May the 30th actually comes and goes and he hasn't performed. Get out of my court. The case is not ripe yet. So standing, mootness, and ripeness, those all come under the category of standing, which is the third of the three things you must consider in order to get your case in court. Jurisdiction, venue, and standing.